everyone, my name is Bhavneeta Limbachia. I'm an associate in the Immigration Department for Russell-Cooke, and today I will be hosting a webinar on British citizenship. Now, this webinar is being recorded, and so you can view it again via the Russell-Cooke website or the YouTube channel. So let's begin with an introduction. What does the term citizenship actually mean? Well, at its very basics, it means the status of being a citizen of a particular country. You can have more than one citizenship and will be known as a dual national. There is no limitation on the number of citizenships you can acquire. However, each country must consent to you acquiring a citizenship of another. Contrary to belief, not everyone becomes a British national automatically. Now, to give you some examples of countries which do not allow dual citizenship, include Nepal, Malawi, and generally the Netherlands. In this webinar, we will be focusing on the process of naturalisation, by which a non-British adult becomes a British citizen. The rules I set out in the British Nationality Act 1981. Now, an interesting fact for you in light of Brexit. In the last 12 months, applications for citizenship by EU nationals increased by 26% to 53,588. Now, EU nationals account for 31% of all citizenship applications, compared with 12% in 2016. This figure is from the year ending June 2019 and published by the Office of National Statistics. So what are the benefits of being British? Oh, you become free of any immigration time restrictions and therefore able to work and live in the UK without any immigration restrictions. You can apply for a British passport and you have unrestricted entry into the UK. You have access to the NHS and the right to vote. Now, the right to live in the UK, free from immigration controls, is called the right of abode. Naturalisation. Now, there are slightly different requirements depending on whether you are married to a British citizen or not. However, the basic requirements include that you are aged 18 or over, are of sound mind, are of good character, resident in the UK, proficient in the English language, and have sufficient knowledge of life in the UK. So let's focus on those who are not married to a British citizen. They would need to illustrate that they have an intention to permanently live in the UK. Now, this can be demonstrated by showing intention for your principal home to be in the UK. And this could be evidence by owning or renting a home in the UK, and evidence of life in the UK, such as holding a permanent job, which may be enough to meet this requirement. You also need to show that you are physically present in the UK 5 years from the date of application. You have not been absent from the UK for more than 450 days during the qualifying 5-year period. You have not been absent from the UK for more than 90 days in the 12-month period before making the application, and you have not been in the UK in breach of immigration laws at any time during the 5-year period. And lastly, you are free of immigration time restrictions during the last 12 months of the qualifying period. Now, in relation to the residency requirement, if a person has overstayed or broken their lawful residence, this will reset the clock for residency. Now, for requirements for those who are married to a British citizen, now it may seem very obvious, but you have to be married to a British citizen at the time or at the date of the application. You must be free from immigration time restrictions on the date of the application, have lived in the UK for a minimum of 3 years prior to applying, must have been physically present in the UK on the day 3 years prior to the application being received by the Home Office. You must not have had 270 days outside of the UK in the 3-year period before making the application, and you must not have had more than 90 days outside of the UK in the 12-month period before making the application. Now, this is slightly confusing. The legislation states that a person married to a British citizen can apply for naturalisation after 3 years of living in the UK lawfully. However, it also states that a person married to a British citizen must have permanent resident status before being able to apply. Now, it takes 5 years for a person on a spouse visa to apply for indefinite leave to remain. The key here is that an applicant who is married to a British citizen would usually have had to reside in the UK for 5 years, but only need to show evidence of residing in the UK for 3 years. Now, I keep mentioning that you have to be free of immigration restrictions. This effectively means you do not have a time limit on your status and no expiry date. So this can be met by showing that you have indefinite leave to remain, settled status, or a document certifying permanent residence. Another requirement is to show that you are of sound mind. This means that you have the ability to understand the application you are making. There is discretion to waive the requirement if the Home Secretary believes it would be the right thing to do in any particular case. To explain the last point, if you are applying on behalf of someone else who is not of sound mind, but there are strong reasons why it would be in the applicant's best interest to naturalise, despite their inability to fully understand the application, then it may be granted. Usually, an applicant's mental condition and the fact that they were in care would be submitted, as well as any care arrangements in place. Let's focus a little bit more on EU nationals. Those EU nationals that hold a document certifying permanent residence will be eligible to apply for naturalisation after holding the document for 1 year. Now, if you do have a permanent residence document and are married to a British citizen, then you can apply immediately. You can see that there are preferential provisions for those married to a British citizen. A key point here is that many EU nationals may be eligible to apply for naturalisation without even realising. Permanent residence can be granted retrospectively, and therefore, if an EU national was a resident from 2000, and that would mean that they would be eligible to apply for permanent residence from 2005. If they applied and received a decision today confirming their permanent residence was granted from 2005, then this would mean that they can apply for naturalisation immediately. However, as we are approaching the end of the transitional period, EU nationals will not be able to apply for a permanent residence document from next year. Instead, you'll only be able to apply under the EU settlement scheme. So similarly, those that have been granted settled status under the EU settlement scheme will be eligible to apply for British citizenship after holding settled status for a year. Now, again, if they are married to a British citizen, then they can apply immediately. A very important point to make is that they will still be required to show that they have been lawfully resident for the qualifying period. Now, this may mean you may be required to show evidence of comprehensive sickness insurance if applicable. Now, just to clarify, settled status is not granted retrospectively, and therefore the date of decision will be the date you are granted the status. As mentioned, EU nationals must show that they were lawfully resident in the UK for the 3 or 5 year qualifying period that they are relying on. This is a fairly new addition to the rules. So if they are married to a British citizen, they will need to show that they were exercising treaty rights during the last 3 years. If they were not married to a British citizen, then they will need to show that they were exercising their treaty rights in the last 5 years. Another requirement is that the applicant must show evidence of knowledge of language and life in the UK. These are effectively two separate requirements, okay, and so both must be met. So the English language requirement, effectively it can be met through 3 different routes. By being a national of a majority English-speaking country. To give you some examples of some majority English-speaking countries, Jamaica, the Bahamas, Canada, Australia, and New Zealand. Another way of meeting this requirement is to hold a valid speaking and listening qualification in English at level B1. Now, those that were granted indefinite leave to remain on the basis of a B1 qualification will not be required to sit another test. Instead, they can use their qualification to meet the English language requirement. Lastly, you can meet this requirement by holding a valid degree, which is either taken in the UK or taken outside of the UK and accompanied by a UK NARIC certificate. Now, there are some exemptions to the knowledge and life in the UK. For example, if you are 65 or over, or have a long-term physical or mental condition that prevents you from sitting the test. Now, if this is the case, then you must show evidence by providing a doctor's exemption form which confirms your conditions. Now, if you were exempt from meeting this requirement when you applied for indefinite leave to remain previously, such as those who held refugee status for 5 years, then you would be required to meet this requirement when applying for naturalisation. You would not be exempt. So let's focus on the good character requirement. So this now applies to all applications and routes to citizenship, and it takes into consideration criminality, international crimes, terrorism, and other non-conducive activity, financial soundness, notoriety, deception and dishonesty, immigration-related matters, and deprivation. Now, with reference to immigration-related matters, this could be if you have evaded immigration control in the last 10 years or helped someone else to evade immigration control, or employed illegal workers at any time. This will have an impact on your application. You must declare all criminal convictions from both within and outside of the UK. A criminality check will be carried out automatically by the Home Office. A criminal history may have an impact on your application, which we will see in the following slide. And the requirement must be met by all applicants aged 10 and over. So this includes registration applications. Now, there are certain categories of persons who are exempt from meeting this requirement, which includes those who apply into the statelessness provisions, and effectively this would mean that they would otherwise be left stateless, those who have no other citizenship, and those who would have been British but for historic gender discrimination in British nationality law. Let's look at the impact of criminal convictions on an application. So if you have a conviction of 4 years or more, then your application will be refused regardless of the time of the conviction. If you have a conviction between 12 months and 4 years, the application normally would be refused, unless 15 years have passed since the end of the sentence. Now, a sentence up to 12 months, an application would normally be refused unless 10 years have passed since the end of the sentence. Now, a non-custodial sentence or other out-of-court disposal that is recorded on a person's criminal record, an application would normally be refused if the conviction occurred in the last 3 years. Now, deception is an important feature which may lead to British nationality being deprived. So if you had practiced deception in any of your previous dealings with the Home Office or any other government departments such as HMRC, then this will be taken into consideration when assessing whether you meet this good character requirement. Now, an application is likely to be refused if deceived and if the deception has occurred in the last 10 years. Now, if deception was previously used to acquire pre-settled status, this will significantly affect the application, and it is likely that the application will be rejected unless 10 years have lapsed since the last incident. Deprivation of citizenship. Well, you can be deprived of your citizenship, possibly if found to have been obtained by fraud, false representation, or the concealment of any material fact. You can also be deprived if the Secretary of State is of the opinion that it is in the public interest to do so, and it would not result in being stateless. Now, this power is being used increasingly in the last few years. Now, reasons may include encouraging or assisting in acts of terrorism, committing war crimes, public order offences, or other serious crime, or carried out acts seriously prejudicial to national interests. So let's quickly go through the procedure of naturalising. So you effectively submit the online application, although there is a paper version which is still available, which can be posted to the Home Office. You enrol your biometrics, and lastly, attend a citizenship ceremony. It is important to remember that the citizenship ceremony is not optional, and in fact, you only officially naturalise as a British citizen once you attend your ceremony. Making the oath or affirmation and pledge at a ceremony is a legal requirement for adults. The ceremonies usually take place at a local authority nearest the applicant's home, and you can even invite guests. Usually, a person has 3 months to attend a citizenship ceremony from when they are granted. However, due to the current COVID-19 pandemic, this has been extended to 6 months. And lastly, just to mention that the current fee for the application at the time of recording this webinar is $1,330. So, unfortunately, if your application is refused, then there are some options for you. Now, there is no right to appeal to a court, but you can apply for a formal reconsideration of the application. And the last resort is a judicial review application. Generally, it is extremely difficult to challenge a refusal by way of judicial review because the Home Office already have a lot of discretion in the rules. So I'll just go through some of the common reasons for refusal. You can be refused on the basis of failing the criminality check. You can be refused on the basis of failing to provide evidence of being lawfully resident for the qualifying period. EU nationals applying may be refused if they fail to provide evidence of exercising their treaty rights during the qualifying period. Not being present in the UK exactly 5 years prior to the date the application was received by the Home Office. Simply not sitting the correct English language test, and failing to attend the citizenship ceremony. I hope you have enjoyed this webinar. If you do have any questions, please do drop me an email. My email address and my contact number are on the slide at the moment. Thank you very much for listening.